Hi everyone, so welcome to this series of Indian polity, and in this series of Indian polity we already have delivered more than 65 lectures, and we were into last segment of Indian polity, and in that last segment as well we already have delivered 2 chapters on political parties and election. This is the third video in this last segment of Indian polity on this election laws. So when I'm saying election laws, what I am talking about? So when I say election laws, I am talking about election laws that is dealing with the election, laws that is dealing or that is relating with the election. So all those laws that has been designed, enacted and passed by the parliament, or all those laws that has been passed by the state legislature. Although this differentiation you will have clarity on, you might argue that hey, does state legislature also does have power to design any law relating with the election? So yes sir, yes madam, that state election or the state legislature also does have limited power by virtue of article 321, and that point has already been clarified to you into the last video when we were discussing with the election, that yes, parliament, most of the laws that has been designed relating to the election or that is dealing with the election, most of those laws has been designed, enacted and passed by the parliament, but by virtue of article 328, right, state legislature also does have that limited right. What kind of limited right they do have, as I told, we already have discussed, so I am not getting into the nitty-gritties. So learning here is that along with the parliament, there are certain areas in which state legislature also can design laws relating to the election. So what is going to be the scope of this particular video? So in this particular video, we'll be discussing few important, not all the laws that is dealing with the election, but only few very important laws that is dealing with the election, right? Although more than 40 plus laws dealing with the election that has been until now, until 2020, more than 40 plus law has been passed by the parliament or the state legislature that is dealing with those laws, that is dealing with election, but all those 40 law will not be discussing. The scope of considering that we have to prepare for UPSC and considering the past tenses of UPSC, right? These two laws are going to be very important, that is Representation of People's Act 1950 and Representation of People's Act 1951, right? Although there are other laws as well that has been passed by the parliament, like you have this this third law, that is again post these two laws, the third law, that is election symbol order, that is also important. Then you do have this anti-defection law, then you have this delimitation commission laws. So these laws are equally important. As far as delimitation law is concerned or delimitation commission is concerned, that delimitation commission we already have discussed into the parliamentary chapter, but that delimitation, some of the functions of the delimitation are few untouched aspect of delimit, although the delimitation commission is scope of this particular chapter, but considering that we had already spent time on delimitation commission into the parliamentary chapter, there we had extended a study on this delimitation commission for around 20 plus minutes, and that's why those aspects that we already have covered in regard to delimitation commission into the parliamentary chapter will not be discussing. I'll expect that you have watched those videos and you will not expect me to duplicate my effort here. So those aspects which are new relating to the delimitation commission, like structure of the delimitation commission or composition of delimitation commission, could not be discussed into the parliamentary chapter. So those new aspects relating to the delimitation commission we will be discussing in this video, but the other aspect of delimitation commission, although in this lecture as well content has been added, you will get PDF, and in that PDF you will get certain new information regarding the delimitation commission, but I will not be reading or I will not be making you explain that particular aspect of delimitation commission. As far as anti-defection law, so as I already told you that here Representation of People's Act 1950 and Representation of People's Act 1951, the two very important law that was passed by the parliament immediately after operationalization of Indian Constitution. And why these laws, Representation of People's Act and Representation of People Act Act 1951 and 1950 were passed immediately after operationalization of Indian Constitution? So see, independent India's first election was conducted when, do you know? 1952. So until 1952 means after from 1947 or from 1950 when our constitution came into force, what was means how we were being ruled? So we were being ruled by the provisional parliament, the parliament which has the constitutional body that has designed our constitution. Same constitutional body started functioning as provisional parliament after constitution was operationalized, and that provisional parliament remained in force from 1950 or from 1950 you can say until 1952 when first election was conducted. Now how that first election will be conducted? You need administration, and you can raise this question that what is the necessity? See, in article 324 to 329, that is part 15 of Indian Constitution, that is dealing with the elaborate provision of the election commission, right? How election, what will be the role of the election commission, what will be the mandate of election commission, what will be the structure of election commission. So when you already you can argue that when we do have already elaborate body like election commission of India, and we do find the mention of this election commission of India in constitution directly itself, and then you do have this article 80, article 81, article 179, article 180, right? So these kind of article 169 and article 170. So when you do have these kind of mention of the elaborate election machinery, and then it talks about Lok Sabha, Rajya Sabha, what will be the membership. So what is the necessity of this Representation of People's Act, Representation of People Act 1950 or Representation of People Act? Now why you cannot go, when you do have this elaborate administrative machinery, right, why you cannot go ahead and conduct the election right away? So the answer of this question, that why do we need these kind of laws? See, constitution, whenever here when we are talking about the election commission, the constitution in part 15 talks only about that 3-member or a multi-member body that it talks about, and how many other kind of commissioner. You do have this chief election commissioner, and other commissioner has been left it to the president. So here in constitution, although has envisioned the role of what will be the structure, right, of the election commission, what will be the role, what will be the mandate, that it will have to conduct this free and fair election, right, periodic election. So all these, what will be universal adult franchise, it is talking about. Article 326 is talking about 18 years age. So all these things has been mentioned into the constitution, but these are just broad guidelines. The skeleton filling has to be done by these kind of law. Here you do have this structure of the election commission, but the pyramidal structure, the vertical pyramidal structure, administrative structure has not been talked into this constitution. That is part 15 of Indian Constitution. It does not talk about CEO, Chief Electoral Officer. It does not talk about necessity of having this district electoral officer. It does not talk about this part 15 I am talking about. This part 15 does not talk about necessity of returning officer, necessity of booth level officer, necessity of your polling presiding officer. So these administrative structure, when I talk about these administrative structure, has been envisioned in these kind of law. You have this Representation of People's Act 1951 that talks about the necessity of administrative structure. You have this Representation of People's Act 1950 that will be talking about the CEO and DO and their roles. So see here the broad guidelines, right, that has been mentioned, that there should be election commission, there the election commission role should be there. So that had been envisioned into the Indian Constitution, but as far as, and that is the job, that is how, means Constitution just specify a broad goal. That broad goal, how that broad goal will be fulfilled, that has been left onto the parliament, that they will be coming up with any kind of law. That law will be mentioning about the administrative structure, that law will be filling this skeleton, right? We are just giving constitution just create these kind of skeleton, right? It thereafter the muscle filling will be done by the laws, various kind of laws that will be brought by the parliament or the state legislature. So that's my argument, that why this Representation of People's Act 1950, why this Representation of People's Act 1951, why this election symbols order, why this anti-defection. So as and when, means the point is that as and when whatever necessity that will be felt in any area of the election, that will be felt by parliament, right? As and when they will be feeling the necessity, they will be coming. Why this anti-defection law came only in 1985 when you had this Rajiv, because there was this problem. Rajiv Gandhi government had secured this huge mandate of 486 out of that 543. And there was fear that was dangling in this Rajiv Gandhi government, that because we cannot please all these 486 member of parliament and there are chances of defection, so they felt that there should be this kind of law. So as and when, means the point is that this has been left on the parliament, that yes, we have broadly guided you by the constitution that what is our expectation from an institution like Election Commission of India, but depending on the situation we are leaving it on you, the parliament, that you can, depending on the situation, you from time to time you keep coming up with these kind of law to reform this election commission, right? And that's why we, at post-independent India, you do have these various kind of laws that has been designed by the parliament from time to time. So now I hope your question would have been replied, that why do, despite constitutional mention about the Election Commission of India, why do you need these kind of law, that is Representation of Peoples Act 1950 and Representation of Peoples Act 1951. Broadly speaking, if I put this Representation of Peoples Act 1950 and Representation of People Act 1951 into, if I broadly keep these two laws into one basket, and if I try to find out the broad goal of these two law, common broad goals. So this law is going to talk about the conduct and regulation, how the parliamentary election, how the state legislature election will be, means giving the administrative. So the common goal of these two law is creating administrative structure first of all, because this was the biggest challenge in 1950 when you are going for a election in 1952 for the state legislature and the general election to the Lok Sabha, you need some sort of administrative structure. So broadly these two law deals with creation of that administrative structure that we do have today, right? Creation of that administrative structure. And then the second thing, that was the first thing, and the second thing is that how actually these election, conduct of election of the parliament, how these elections will be conducted, right? So these two law primarily deals with the creation of that administrative structure. And so the primary goal of these two law, that is Representation of Peoples Act 1950 and 1951, is to creation of administrative structure and then regulating the conduct of parliamentary and the state legislature election. Now let us discuss the specific provisions of Representation of Peoples Act 1950 and the specific provisions of what are the provisions that Representation of Peoples Act 1951 deals with, and what are the provisions that Representation of Peoples Act 1950 deals with. The specific. So far we were discussing this Representation of Peoples Act 1950 and Representation of Peoples Act 1951 broadly. Now we are going to discuss the specific provision, what area or what is the scope of this RPA 1950 and what is the scope of this RPA, or what aspect of election that has been covered in RPA 1951. So RPA 1950, first of all, it discusses about the allocation of seats into the Lok Sabha and Legislative Assembly. Now here you might raise a question, if you have studied well this union government section that we already have covered. So there we covered regarding this article 80 and article 81. Do you remember this, what this article 80 and article 81 deals with? So article 80 were dealing with the seat allocation into the Rajya Sabha, and article 81 deals with seat allocation to the Lok Sabha. Similarly, you had this article 169 and article 170. Article 169 deals with allocation to seats of various legislative council of the state if the state has chosen for having this legislative council, and similarly this article 170 that deals with legislative, the allocation of seat to the various legislative assembly. This information that you already have on this slide. So the question here arises, or the question that you can raise, is that when this seat allocation in the constitution has already been done in various articles, so why this Representation of Peoples Act 1950 also talks about allocation of seats in Lok Sabha and Legislative Assembly? So here the article 80 and article 81 or article 170 that talks about allocation of seats into various legislative assembly of various state, here it discusses about the maximum or the minimum seats that can be allocated or that should be allocated. So the maximum seats was 552, right? Do you remember that? And similarly here as well into the legislative assembly as well, in regards to what would be the maximum ceiling or what would be the maximum seat allocation to any state's legislative assembly, right? So that has been defined in this article 170. So the maximum and minimum ceiling has been defined, but ultimately it has been left to the parliament that how many seats into particular year. So for example, in 1952, when election was conducted to the Lok Sabha, unlike today, when election is conducted for all 543 seats, right? Election in 1952 was not conducted for all these 543 seats, rather the election was conducted only for 489 seats. So it depends entirely onto the parliament that how many out of maximum allotted seat, that is 52, right? Depending on the population, means it was only after the 6th Lok Sabha election that we started utilizing all the available seats. Although all the available seats still we are not utilizing, some of the seats has already been left for this POK. I am talking about this Lok Sabha. Some of the seats has been left for the UTs, Union Territory, to be utilized. So all the maximum seat strength of the Lok Sabha that has been envisioned into this Article 80 we are still not utilizing, but this provision RPA, Representation of People's Act 1950, that talks about that at that moment what will be the maximum seats that will be allocated to the Lok Sabha and how exactly the Lok Sabha election will be conducted and how exactly the election to the legislative assembly will be conducted. So that is one aspect, right? So I hope the constitutional, what is the constitution that talks about in this Article 81 and what aspect this Representation of People's Act when it says that allocation of seats into the Lok Sabha or legislative assembly is going to talk about. Now the second provision of this Representation of People's Act 1950 is delimitation of the constituency. What is this delimitation of the constituency? So delimitation, I already hope that you will have an idea. Delimitation of constituency is nothing but drawing the map of parliament, either parliamentary constituency or assembly constituency, right? That how many people in a particular parliamentary constituency, right? If parliamentary constituency, let us see Delhi Kent or Chandni Chowk. These are two parliamentary constituency of the Delhi. So what will be the geography of this parliamentary constituency or assembly constituency and how many people will be there in this constituency, parliamentary or assembly constituency? So this job of drawing the constituency, drawing the geography of constituency and deciding that how many people would be there in a particular constituency, although the attempt of Delimitation Commission that we already have talked in, the attempt of Delimitation Commission is to ensure that this population ratio in every constituency remains same. So if in a particular constituency, if there are 10 lakh people, so in the other constituency as well there should be 10 lakh, means not exactly, but this Delimitation Commission at least tries, at least attempt that there should be as near as possible, right, the population ratio of each constituency, be it parliamentary constituency or be it assembly constituency, so that the member of parliament or member of legislative assembly who is supposed to represent that particular assembly seat or that particular parliamentary constituency, he does have ability that he could address the or fulfill, he could politically meet those people, could fulfill the aspiration, and that's why the size of this parliamentary constituency becomes very important. Now without deviating from the topic, this Representation of People's Act 1950 talks about delimitation of the constituency. So right now the constituencies that we do have, political constituencies or the parliamentary constituencies or the assembly constituencies that we do have, that has been decided by whom? That has been decided by the Delimitation Commission, and this Delimitation Commission has been constituted 4 times until now, right? After 2002 it was decided by this Delimitation Commission law in 2002, rather in 2001 it was decided that for next 25 years, that is until 2026, there will be no Delimitation Commission, rather the next Delimitation Commission that will have, we may see after this 2031 census, and that has been frozen. The Lok Sabha seat will also not be increased until this 2026, rather until this Delimitation Commission comes into the force, the next Delimitation Commission, right? This Lok Sabha seats also remains, and all these information we already have discussed. So Delimitation Commission will be, this is the job of redrawing or drawing the map of parliamentary or assembly constituency is the job of Delimitation Commission. But here the point is, and here you will have to be focused, that Article 82 that talks about this Delimitation Commission. The first mention of this Delimitation Commission in Indian Constitution you will find in this Article 82. What this Article 82 talks about? So Article 82 talks about, if I tell you in lame language, the Article 82 says that after each census, and how, when this census is conducted, so census is conducted every 10 years. So you had this census in 2011 and there will be next census in 2021. The process has already started. So Article 82 talks about, Article 82 which does have mention of this Delimitation Commission, Article 82 says that after every census that has been conducted after 10 years, right, there will be a law that will be brought, there will be law that will be passed by the parliament, not by the state legislature, but the law that will be passed after the census has been conducted. A law will be passed by the parliament, and through that law parliament will be instituting this Delimitation Commission, and based on the population or based on the increased population, Lok Sabha seat will be increased and the assembly seat will also be, means there will be redrawing of the map of these constituencies, right, and based on the increased population or decreased population, Lok Sabha, this will be decided by the Delimitation Commission, right, whether the Lok Sabha seats should be increased or decreased. So there is no question of decrease because our population is continuously increasing, and similarly depending on the population, increased population of the particular state, assembly seats will also be increased. But what is the provision of this? So here again this learning is important, but Article 82 talks about that when census has been conducted, then only parliament will be coming up with the law, and you did not have any parliament. What you had in 1950, what you had this provisional parliament, and census had also not conducted. So who will be in that situation? Who will be, because for conducting this parliamentary election, right, constituencies needs to be drawn, right? So who is going to draw in that event when you do not have Delimitation Commission, whose job, it is the job of this Delimitation Commission to draw the boundaries or to design these parliamentary constituency. In absence of that Delimitation Commission, because census has not been conducted, and the constitution says, Article 82 says that only after census has been conducted parliament will be, and parliament is also you do have this provisional. So in that kind of situation, the article Representation of Peoples Act 1951 is going to empower president in consultation with the Election Commission of India. He or she will be drawing the map of the parliamentary constituency and the assembly constituency in the state, so that election could be conducted into 1950. So if there is a question into the that the first delimitation exercise was conducted by whom, so the general or the logical answer may be the Delimitation Commission, because we have studied that it is the Delimitation Commission which conducts or which draws the map, but the right answer would be no, the first delimitation exercise was done by the president in consultation with the EC. So that is the second provision of Representation of Peoples Act. Now the third provision of Representation of Peoples Act. So the third provision of Representation of Peoples Act talks about qualification of the voters. Now here you do have clash of these words. Qualification has already been talked in 1950. Along with 1950 that talks about qualification, this word qualification is there in 1951 as well, but there is a basic difference. Here 1950 talks about qualification of the voter, that what will be the age of a person who will be voter. So initially it was 21 years. By 69th constitutional amendment in 89, right, 1989, this age has been now reduced to, for a person to be voter, this age has been reduced to 18 years. So any person who attains this age on 1st of January of any year, he is eligible to register himself with Election Commission of India as voter. But the qualification that has been talked into 90 RPA, Representation of Peoples Act 1951, this qualification is not of a voter, but those people, those who aspire to become MLA, those who want to contest the election of MLA or MP. Along with the qualification, the certain disqualification parameter or certain grounds of disqualification has also been mentioned into Representation of People's Act. And this what are the grounds of disqualification? If a person, so initially when you were not MLA and MP, so what was the qualification that is required to contest an election? Now you have become MP or MLA, so on what grounds, what corrupt offenses or what practices that you will indulge in, on those grounds, right, you can be disqualified. So that has been mentioned into this Representation of People's Act 1951. At this point again, the grounds of disqualification of MP and MLA we already have discussed into the parliamentary lecture when we were discussing this Article 102 and Article 191. Do you remember Article 102 and 191? Right. So there, along with this Article 102, which talks about there are certain grounds on which member of parliament and member of legislative, like unsound ground, like if he ceases to be a citizen of India, if he becomes bank corrupt. So all those grounds has been mentioned into this Article 102, and for a state legislature this grounds has been mentioned, or this ground of disqualification has been mentioned into Article 191. So along with there, means along with Article 102, we had talked in through the parliamentary lectures itself that there are certain, along with the disqualification ground that has been mentioned in Article 102 for MP and 191 for MLAs, right, there are certain ground that is mentioned into this Representation of People's Act as well. And if any MP or any MLA has violated those grounds or come up on those grounds, then MP and MLAs can be disqualified. So that is the basic difference between qualification and disqualification. The fourth provision of this Representation of People's Act 1950 is manner in which Rajya Sabha seats will be filled in by the union territory. We do have currently, how many union territories that we do have? 8 union territories, right? So how the Rajya Sabha seats will be filled by these union territories. So that manner of RS filling, Rajya Sabha seats filling, has been discussed in RPA 1950. Then officers related to the conduct of elections. So it will be talking about having election CEC, chief, not CEC, rather CEO it will be talking about, because CEC has already been talked into the part 15 of Indian Constitution from 324 to 329. So because it is mentioned, so it will be this RPA 1950 will be talking about having the chief electoral officer in every state or union territory. Then it will be talking about DEO, then it will be talking about ERO, then it will be talking about RO, right? So whatever officer that is required for the conduct of election. So these are the provisions of RPA 1950. What will be the provisions that will be dealing with the Representation of People's Act 1951? So how the election will be conducted for the parliament or the state legislature, that has been talked in Representation of People's Act 1951. Qualification and disqualification parameter we already have talked in, right? So I'll not be delving into, I'll just give a glimpse of, because this point we already have discussed. Do you remember this image? Right, this image into the this has been directly copy pasted from this parliamentary lecture. I need not to design. So I hope this image you already have seen. So these are the grounds that has been mentioned into the Constitution in Article 102 and Article 191. Right, Article 102 deals with the grounds of disqualification for member of parliament, those members belonging to the Rajya Sabha and Lok Sabha, and Article 191 deals with the grounds on which state legislature, although the articles are different but the grounds remains similar. And besides that, there are certain grounds that has been mentioned directly into the Constitution. You have Representation of People's Act 1951 as well, right, that does have certain grounds on which MPs or MLA, if they does fall on those grounds, these MPs or MLAs can be removed, right? So what are those grounds? Let us discuss. So if any MP or MLA has indulge into any kind of election offenses. So what are those elections? So during elections, there are certain ground that has been mentioned, right? And if any candidate, any member of parliament, any member rather, not member of parliament, any member, does not matter whether he is a voter or he is a contested who is contesting the election, or any official as well, if he is falling under this category of election offences. So what will be the election offences? So suppose if you try to disturb this communal harmony, if you try to disturb this or create class enmity, if you try to promote that caste conflict, so those promoting hatred among different caste or class enmity, right? So that will be considered as election offense. If you are bribing as a candidate, if you are bribing, or even as a political activist, you are affiliated to any political party, you are a political activist, and you are trying to bribe any voter, if you are trying to intimidate any voter, if you are trying to influence any voter, and if that will be proved, then again that will come under this election offenses. Then spreading religious disharmony or selling liquor or consuming illegal drugs as well as other chemicals during that period of election, all those things, all those will be considered as election offense. And if any of these charges are proved against you, does not matter whether you are a citizen, that will fall under this election offenses, and then you will be disqualified from contesting election for 6 years. Here again you need to be careful. What will be the period? So 6 years you will be disqualified. You cannot contest election for next 6 years, plus whatever sentence that has been decided for these crimes, right? Whatever, whether 6 months or 2 years or 3 years, whatever sentence that has been decided, that period plus 6 years you cannot contest election, right? I hope you will have an idea on this point, right? So this comes under this election offenses. Then any crime that you may have conducted once you have become, so this is during the election, right? Whether you are citizen, whether you are political activist, whether you are contested, whether you are already incumbent member of parliament or member of legislative assembly. Now this point arises, or this point applies to members who are already member of legislative assembly or member of parliament. So being a member of parliament and being a member of legislative assembly, if you have committed any crime and that crime has resulted into 2 years of sentence or more than 2 years of the sentence, then again you will be disqualified from contesting the election for a period of 6 years plus what will be the period of that sentence. So if the sentence is of 3 years, so you cannot contest the election for 3 years plus 6 years, that is 9 years. If then into the election, right, it is the rule, election commission has made a rule that you will have to DEO, district election officer, once your election has been completed, right, and you are a winner, so within the 30 days you will have to, whatever expenses that you have incurred during the election, right, you will have to file the account of that expenses within the 30 days to the DEO. If you fail to file that account, again that will be falling, or that will be considered as violation of this Representation of People's Act provision, and then again you will be, means whatever, or whether it will be fine or any kind of sentence, so 6 years plus that period of sentence. Then if you have any kind of interest in government contracts, so that will, if you as being a member of parliament or being a member of legislative assembly, if you does have any kind of interest into government services or government contracts, right, what is this? This is nothing but conflict of interest, right? So then again you will be, or your services will be terminated. If you happens to be a director or MD into any organization or in any company where government share is more than 25%, and if you have, after becoming member of parliament and after member, so before becoming member of parliament, before becoming member of legislative assembly, if you were a member, not an issue, but after being member of parliament and member of legislative, if you are deliberately not resigning, and if by any means if the information is revealed, then again your services will be terminated. If you are dismissed from government services for showing any kind of disloyalty, or if you have promoted enmity, or if you have promoted any kind of social evil like this untouchability and dowry, right, that is civil offense under 1955 law, right? So if you have promoted any, or if you have been indulged into any such offense and you have been jailed, then your services, or your as a member of parliament or member of legislative assembly, right, your services will be terminated and you cannot contest election for a period of 6 years plus the period of sentence. So I hope the criteria for disqualification, these are the only criteria that is mentioned into the Representation of People's Act 1951, right? These criteria are mentioned directly into the Constitution in Article 102 and Article 191, right, for MPs and MLAs, right? So this is the second criteria, that qualification and disqualification for the member of parliament and member of legislative assembly. Then the third thing that this Representation of People's Act 1951 talks about, having administrative machinery for the election, that we already have talked about. Then how the registration of political party will be. So you have this election order 1968, right, and it means election and this empowers election commission that any association, any group that wants to be called as a political group, right, that group or that association will have to approach Election Commission of India to obtain or to register itself. Then if there is any dispute among, so your party has been created now, if there is any party split that happened into the Tamil Nadu while around 3 years ago between in this AIDMK, where there were rival claims on this AIDMK symbol. So it is the Election Commission by Election Symbols Order 1961 that empowers that if there is any claim, right, by Election Symbols Order 1960 itself, right, this Election Commission has been empowered that if there is any claim by the rival group, it will be the Election Commission will be the final authority to decide on, right, depending on किस rival के पास कितने, how many office bearers claims that a particular rival group does have, and what support it does have from that party's MLA and MP, right. So these are going to be two determinant factor by the Election Commission of India to take the decision whether rival parties claim or rival or the faction group claim is real or not, or which party or which group should be considered as a real claimant to party symbol or the party head. So that registration of political party, if there is any doubt on this claim, if there is any dispute on election, that will be decided by the Election Commission. That what will be the practices that will be considered as corrupt practices, that we already have discussed into this disqualification parameter. So these are the practices that will be considered as corrupt practices during the election, right, and any person found guilty on any of these above charges shall be disqualified for a period of 6 years in addition to the sentence period, right. So all these points of 1951 as well, corrupt practices and electoral offences, and when by-election will be conducted. So when does this by-elections are conducted, and what is this by-election? So by-election is nothing but an election procedure itself, election procedure whereby elected member of parliament, if elected member of parliament and member of legislative assembly while being in office, if he or she dies and the period or the remaining period of assembly or the Lok Sabha is more than 1 year, or at least 1 year, then election to that seat will be conducted by Election Commission of India. Means even if it is less than 1 year, then it will be incumbent on Election Commission of India. You cannot, any political party cannot compel Election Commission of India to conduct. And why this 1 year cutoff has been put up? 1 year cutoff has been put up on this Election Commission because see, if the tenure of that Lok Sabha or assembly is only 1 year when this member of parliament or elected member of legislative assembly died, so 1 month will be like notification will be issued, then nomination will be filed. So 1 month will go or 2 months will be going into that process itself, and thereafter a newly designated or newly elected MP and MLA, he will reside in office only for 8 months or 9 months or 10 months. So there is no point of involving this huge amount of resources and disturbing the public, right? So that's why this provision, this cutoff of 1 year has been taken up. So all these things and only these headings, if you can remember, right, Representation of People's Act 1950 and 1951, right, you can remember all these things that we discussed, right, all these things has already been put up into this textual format, right. So you can study all these things, right. I'll be providing you the PDF and PPT. Representation of People's Act 1951 Election Symbols Order, right, that empowers this Election Commission of India to decide on any kind of dispute that may arise due to rival parties, faction or faction parties claims. All these things has already been discussed. What about the Delimitation Commission? So this Delimitation Commission we did not discuss, and the Delimitation Commission, although we already have discussed, but this aspect is new, and let us discuss this aspect. So the composition, this is going to be, the Delimitation Commission is going to be a 3-member body, and it will be consisting of a retired Supreme Court judge, not the High Court judge, so retired Supreme Court judge, plus Chief Election Commissioner and respective state election commissioner. So if Delimitation Commission has been constituted by law by the parliament for whole of the country, so again here the learning is that Delimitation Commission scope will also be defined into that law itself by the parliament, that whether in what all area you have to conduct this delimitation. So delimitation, the scope of delimitation may be extended to all over India as well, and it may be extended only to to cater to the needs of 4 states or 5 states as well. So if it has to cater, or if the scope has been defined for whole of the India, then the state election commissioner for all the state will be the members of that Delimitation Commission. But if suppose the Delimitation Commission has been constituted only to look into the 4 states redrawing boundaries, right, then only those 4 states. So these 2 members, that is retired, any of the retired Supreme Court judge plus Chief Election Commissioner is going to be common, but the number of state election commissioner depending on the scope of Delimitation Commission will keep varying, right. These points we already have discussed. The Delimitation Commission is a very powerful body, right. Once it has been constituted, then it will, its orders or its suggestion or the law that it has created will be binding even in on Lok Sabha or the Rajya Sabha, the very 2 bodies that had created this Delimitation Commission. Once it has been constituted by law, its orders are to be implemented even by, although formally Lok Sabha and Rajya Sabha will be ratifying the orders or the law that it has made, even the Supreme Court cannot look into the orders of this delimitation. Such powerful this body is, right. So that is the thing. The first delimitation exercise was performed not by this Delimitation Commission, but by the President in consultation with Election Commission on what was the basis. So the basis of that delimitation exercise was population that we had in January 1950. However, ECI suggestion, a dedicated independent Delimitation Commission was set up in 1952, then in 1963, then you had in 1973, and thereafter in 1976 by 42nd amendment it was decided, right. Why it was decided we already have discussed into the parliamentary, most of you already would know. So it was decided that no longer this Lok Sabha seat will be increased, whatever Lok Sabha seat that was contested before this, right, the number of Lok Sabha seat will remain fixed for next 25 years, for next 25 from 76 to, because it was conducted, 42nd amendment came into 1976, and by 42nd amendment this number of Lok Sabha seats were frozen for 25 years. So it was again in 2001 by 84 constitutional amendment, again the number of Lok Sabha seat has been frozen until 2026, and it has been decided that Delimitation Commission, right, the increase in Lok Sabha, number of Lok Sabha seat or assembly seat of various state will be decided by Delimitation Commission, and that Delimitation Commission will not be sitting until the first census after this 2026. So after 2026 first census will be conducted in 2031, and after that census only you can have a Delimitation Commission if again this any parliament, right, does not come up with any kind of such constitutional amendment like we had in 42nd constitutional amendment and 84th constitutional amendment freezing the number of Lok Sabha. It might be that political, because this is a political sensitive, this number of seats was frozen because of pressure from the south, and pressure, when I am saying, it was not an illegitimate pressure. They do have right reasons, because they have conducted population control measure, which states, these Bimaru states like Bihar, UP, although the terminology Bimaru state you should not be using into the mains, because the Niti Aayog has completely changed these names. This terminology does have a negative connotation, rather it hurts the dignity of the state as well. So even I should not have been using these kind of. So when you have these states UP, Bihar, Rajasthan, where you have this more amount of childs or more population that is continuously growing, and there on the other side you have these four southern state which does have taken population control measure. In that event, if Delimitation Commission would have been allowed to give its natural judgment, they would have given the natural judgment that their representation based on the population, because the Delimitation Commission's exercises that the based on population, they would be recommending increase into the assembly seat, and they would be recommending increase into the Lok Sabha representation of the state which does have large amount of population. So just by virtue of increasing the population, these states into the northern India would have got more representation into the Lok Sabha, they would have got more representation into the assembly, and when they have more number of assembly seats, they would be getting due advantage in presidential election. And if they do have more seats into the Lok Sabha, they will have that particular state which does have more number of seats into the Lok Sabha, they will have political advantage at the national level. What kind of political advantage? So they would have more negotiating power into the Lok Sabha. Additionally, why do we call that most of the time prime ministers comes from the UP? Because the number of seats that UP, if you can polarize as a politician, if you can polarize election into the UP where you do have 80 number of seats, and if you could secure somewhere 60 or 65 seats, then your party can easily gain the majority, or at least come near this majority mark of 272. So that kind of advantage, because and from that kind of advantage these four southern states would not have got, and that's why it was decided that just because these four southern state has taken population control measure, right, so they should not be disincentivized, right, if Delimitation Commission would have given its natural judgment. And that's why, that was the reason that after 1972 you have Delimitation Commission that is being commissioned only in 2002. In 1981 after this census, in 1991 after this census, right, there was no Delimitation Commission that was constituted because of this reason. So I hope all these Representation of Peoples Act 1950, Representation of Peoples Act 1951, Delimitation Commission 2000, so all these things you will have clarity on. With this we are wrapping up this lecture with these 3 MCQ, right. So this is just a moment. So this is the first MCQ. Just a moment, let me clear the screen. First MCQ, second MCQ, and the third MCQ. So these are the 3 MCQ that I expect you to attempt until we come up with the next lecture on a very important chapter, that is election reform. What are the electoral reform that has happened into the post-independent India in various area, until we come up with the next lecture. Till then, bye.